Hello. It's Attorney Mike Gremlin coming to you from Chicago. As usual, I got a really fun one. Robin Lee Miller sent this to me. To her credit, she sent it to me on time, but I was actually practicing law. So, since I cleared that up, we're going to get into it. We've got ourselves, I think, a soft-sit squatter, certainly a vexatious litigant, it appears, in front of Judge Simpson. It's hilarious. The level of stupidity. It is absolutely fantastic. Let's give it a look, shall we?
Why?
They're on their sides.
No, I'm going to give it to Lee. Why are you up here? Here.
You don't put that on the front, yes.
This is that.
Yeah. However, she filed more stuff.
Okay.
Yeah.
Thank you.
That's his clerk telling him you got some serious crazy on the way.
Court does call the case of BMC Rio LLC versus Nettie Whitlow and Yolanda Whitlow Tice.
Good morning, Your Honor.
Good morning, sir.
Good morning, Your Honor.
Good morning. State your appearance, please.
All right. Ian Redmond, P70599 on behalf of the plaintiff.
And your name, ma'am?
Doia Banks occupant.
Pardon?
Doia Banks occupant.
Doia Banks occupant, Your Honor.
You'll note that her name did not appear in the caption when he called the case. That should tell you everything you need to know. Actually, it does.
Okay. So you're not Miss Whitlow?
No.
So what is your position in this case as you see it?
If I may, Your Honor.
Okay, good. Go ahead.
Ms. Banks claims to be an occupant of the property. She filed a bankruptcy case listing the property as hers. The bankruptcy stay was lifted, which gave rise to our motion to reopen the case. The order lifting stay I would like to present to the court because it has some interesting language in it, Your Honor, which includes, it is further ordered that the bankruptcy court finding this filing of this petition was part of a scheme to delay, hinder, and defraud VMC REO LLC. Additionally, Your Honor, the bankruptcy court ordered, notwithstanding Rule 4001A3, a bankruptcy rule,
Right.
creditor VMC REO LLC may execute on its order immediately. The order shall be binding and effective despite any conversion of this bankruptcy case to a case under any other chapter of Title 11 of the United States Bankruptcy Code. Further, that the recording with the appropriate governmental entity of this order shall constitute a bar to refiling any case under any chapter of Title 11 of the United States Code as to the property located at 5779 Pinecrest Estates Drive, Ann Arbor, Michigan.
Wow.
The property in this case. A debtor in subsequent case under this title may move from relief from this order based upon a change of circumstances or for good cause shown after notice and hearing. Said bar shall be for 2 years from the entry of this order or until such time creditor relinquishes their rights to the property. This order came out June 24th of this year. I have a copy for you.
Okay, I'm going to break that down in regular English. That's the bankruptcy court. I'm going to translate for him, saying this is the biggest scammer we have ever seen. We are on to her. We anticipate additional filings to continue this squatting, and we are cutting it off right now. I want any other bankruptcy court judge or any other judicial official to realize what they are dealing with immediately upon seeing this order. That's what it's saying. That is not typical. They don't like to do that. That is a bankruptcy court going out of their way. I mean, they do it in legal terms, so it sounds all clean, but that's nasty as it gets in an order.
All right. Thank you.
I will note, Your Honor, that Ms. Banks has filed an appeal of that order in the federal Eastern District of Michigan. That appeal is pending, but the status quo as of right now is that there is no stay, and that order lifting stay holds until such time as the appellate court does something. Additionally, Your Honor.
Okay, so when you file a bankruptcy, there's a presumptive stay, so you can't proceed with litigation surrounding the subject of the bankruptcy. They're like, no, this is not meritorious. There is no stay. We're lifting the stay. It's over. Proceed. Go ahead. Take your property. Do whatever you need to do because all this is nonsense.
Yes, go ahead.
Additionally, Your Honor, there is no stay from the appellate court. They have not issued a stay, and in fact, it would be appropriate that there would be a bond placed or an escrow order of some sort, because BMC has been the owner of this property for the past year and does not have access to it. Additionally, Your Honor,
There's more. Go ahead.
there's a lot going on.
Yes.
Additionally, Your Honor, Ms. Whitlow, who, as far as I know, actually
Judge Simpson has picked up what the bankruptcy court is laying down.
exists, but I don't have any evidence to that
He's
effect.
figured it out.
Has not appeared in any hearings in this court. Did not appear for her deposition that she was noticed for in the federal case. And in a federal case, the federal court issued a show cause order to Ms. Whitlow that she had to present certain documents from this court, which she failed to do. Her deadline to do so was, I believe, July 3rd.
By the way, I should mention this attorney is doing an excellent job. He's done his homework. He's laying it out efficiently and dispassionately, and he's right.
Let me confirm that. Oh, no, July 10th. And she did not supply any of those documents. I can present that show cause order if you would like.
I don't know that I need that because
Okay.
I'm not.
The reason that I mention all of this, Your Honor,
Go ahead.
is that this is $1 million house in Ann Arbor that Ms. Whitlow purchased with a mortgage and less than a year later defaulted. The foreclosure went through, the sale occurred, the redemption period expired, and we came forward to evict. Since then, there have been multiple bankruptcies. Ms. Whitlow filed 2 different bankruptcy cases. A young man who apparently lives in Arizona filed a bankruptcy case and listed this property as his residence. Ms. Banks has filed a bankruptcy case and listed the property as her residence. It should also be noted that Ms. Banks was a bankruptcy preparer and has been forbidden from.
There you have it. And it's wild because she doesn't know anything. So she was a bankruptcy preparer, so she has some like very specific knowledge of bankruptcy stuff, but she does not understand law at all, as you'll see. and it's interesting, but so now we have 3 bankruptcies filed. All of that is to get stays. They're not actually seeking relief in bankruptcy. It's pure fraud. These people should be put in jail for perpetrating fraud upon the court. That's what should be happening here.
The bankruptcy court from preparing bankruptcies for anyone other than herself. The order lifting the automatic stay talks about that scheme of fraud. I list all of these things to show that the scheme continues. And that's why we would like to reopen this case, because there is no stay in place. We would like to move forward with an immediate eviction, at most an 11-day vacate. And if for some reason that would not be amenable to the court, we would ask for an escrow order or a bond. On $1 million property, I think it would be reasonable that $10,000 a month.
Realistically, no. If you're poor and stupid, the courts will lean. If if a billionaire tries this crap, yes, they're going to jail. That's it's not fair, but that's the truth.
Rent would be reasonable.
Right. Thank you. Ma'am,
Yes, Your Honor?
what do you want to tell the court?
Well, just for 60 seconds, and then I wrote something up because I am nervous, quite nervous.
You should be nervous. You stone cold caught. It appears for all the world that you're a criminal. And now you're in court with no standing, running your mouth on a case where you don't have an appearance. Well, let's see how it goes.
But I, Doia Banks, respectfully appear specially and conditionally for the sole purpose of protecting federally vested occupancy rights and opposing unlawful state action. I expressly do not consent to this court's jurisdiction and do not.
Well, then
Any rights.
you are not a named party. So if you're not consenting to this court's jurisdiction, sit down.
Oh,
You can.
I do not consent to this court's jurisdiction. However, I am seeking relief despite the fact that I'm not party to the case. Could you be any dumber? Could you be any dumber than that? I possibly. Maybe you could forget to breathe.
Go, because you're not a named party.
I have a lease.
You are not a named party on this. You may have a lease with someone else, and
No,
then
I have
you
a
can
lease
go
with-
challenge it. With who?
With Whitlaw. Ms.
Then
Whitlaw.
you need to go against Miss Whitlow.
Pardon me?
Then you may need to go against Miss Whitlow. But if you're not consenting to the jurisdiction of this court, you might as well just sit down. You are not a named party. I do not have to hear from you.
I don't know. I'm guessing Miss Whitlow's in on the fraud. I could be wrong. I don't know. But nonetheless, they are a named party and not here. And they are on the verge of losing everything, as well they should.
Oh, I see. So I need to,
I don't know what you need to do, but
well, let me respond.
to what? You're not consenting to the jurisdiction of this court. Why am I hearing from you?
I'm recanting
You're recanting what?
what I just stated.
Which part?
The part that I stated that I'm not, oh, I lost my spot, not consenting to this court's jurisdiction. So,
Oh, honey, you lost more than your spot. You lost the plot. You lost the case. You lost everything. You're not party to this. The people who are party to this that you claim to have a contract with aren't here and are about to lose whatever rights, which are probably fraudulent anyway. But to the extent they had any rights, they're about to lose them. So you've contracted with people going down in flames. Good luck.
I'm going to recant that
So you are consenting to this court's jurisdiction?
at this moment.
Well, no, it doesn't work that way. You don't get to say, well, now it's okay, and then not later say no.
Okay.
You know,
Judge, I only consent to the jurisdiction to the extent that you can help me. If you enter an order and I don't like it, well, then there's no jurisdiction. I think it's pretty easy. I think it's pretty easy for you. I don't understand why you don't get it, Judge Simpson.
what? Here's the problem. You've not filed anything with this court.
No.
So I don't know why, on those grounds, why I'm hearing from you.
Okay.
All this is an attempt to delay the writ of eviction via bankruptcy filings. That's it. Nothing more. Just more free stuff. Can I live in somebody else's property that I'm not paying for? That's all.
If I may, I do have time, I do believe, to go file an answer and counterclaim. I was just led under
An
false
answer and counterclaim to what?
to their complaint for eviction.
Yeah, you don't answer a complaint unless the complaint's been made against you. The complaint has not been made against you. It's been made against the Whitlows. They could file an answer or counterclaim, whatever they want to file. But you're not party to this. Run along.
You have a lease with, allegedly, with Miss Whitlow.
Correct.
Then that is who you need to pursue it against,
Okay. And
or whatever the heck you're doing.
well,
Because you don't have, there is no privity of contract to the extent there would be, or relationship as between the plaintiff in this case and you.
okay, I'm not really understanding, but
Well, let me put it a little bit more simpler. If I grant the relief of the plaintiff in this case and grant an order of a judgment and an order of eviction in
Okay.
10 days,
okay,
any claim of your interest in that property, you have to go after the Whitlows because that's the only person you have a contract with. Allegedly have a contract with.
okay. No, there is an actual contract.
I don't know that, ma'am.
We've actually been.
I don't know that.
Okay. I know you don't know that 'cause it's not before you.
Correct.
I see. I see. So basically the notice of removal that the Whitlows did,
They are not here. I don't know. I have documents that are not, that they filed with this court that are not signed. So I don't have to accept them. She has not appeared before this court, or they have not appeared before this court. And so as far as I'm concerned, any relief they're requesting, I can, and as of right, deny, and it should be denied also on the merits of whatever their motion is. But I can deny it because they're not here.
okay. Again, stating to me, I want to make sure I'm clear that my issue is with the Whitlows, not with VMC.
Ma'am, I am not giving you legal advice.
No, I
You're
don't-
telling me that you have a contract. I do not know that you have a contract, but if you wish to enforce that contract, that's who you're going to have the issue with. You're not going to have the issue with the plaintiff in this case because they have right to own the property.
Okay. All right, Your Honor, I will speak with the Whitlows that I have finally got an understanding of everything. And I will speak with plaintiff's attorney as well and continue to communicate with Remax, who has came by the house several times.
All right.
All right. Even though you're not part of the case, you need to go to conjugation camp right now.
Based upon the representation of counsel, I'm going to grant their motion to reopen this case. I'm going to issue a judgment in the plaintiff's favor for possession with a writ to issue 10 days of my signing. Should the matter be appealed,
Happy birthday.
also contained in that judgment in order, the appeal bond I would set at this time at a rental rate or a rate, and I have looked at the property which is involved in this matter, and it is a significant property. I don't think the $10,000 a month quite does it based upon my calculations. So any appeal bond would be set in the amount of $15,000 per.
Thank you, Your Honor.
All right.
I will prepare that and present it to you this morning.
Thank you.
May I say something? Our lease payments was not that high at all.
They were not that high, but that doesn't really matter. And you're not party to the case. And you're, for all the indicators of the world, a scammer. And the judge is going out of his way to make sure that this scam stops. He's doing his part. He's just picking up. He's literally just taking the baton from the bankruptcy court and saying, I got you. I'm not putting up with it either.
I'm not sure what her mortgage payments were. That was not our amount we paid.
Then I'll tell you what. If the Whitlows wish to come and object to my order of $15,000 as an appropriate bond, they may do so. I do not believe that you have standing to object to the court's order. Thank you.
Thank you, Your Honor.
Thank you. That,
I know, you didn't write
and
anything.
we'll await. I did.
Bye, loser.
No.
No, I don't think so. I don't know if Mr. Fink is ready on.
Mr. Fink?
I don't know what her real name is, but as a public service, I hope landlords see this and nobody gets anywhere near this woman because you have nothing but pain.
Are you ready? But hold on. I'm going to take about a 10-minute break because my head is hurting right this minute. Well, it's not hurting. I mean, I could go on, but I need about 10 minutes after that.
Thank you, Your Honor.
Court's in recess.
There you have it. Just straight squatter stuff. I mean, it was pretty. So apparently she worked in bankruptcy for a little bit. They went out of the way and said, you cannot file bankruptcy petitions for anybody else. That's bad. That's personally, we don't believe you. We think you're a fraud on all fronts. We are not accepting any filings that you had anything to do with. That's the thing. Is Miss Whitlow an alter ego? There are three possibilities. She actually is Miss Whitlow, but she can't appear as both in the same day. It is in fact a separate person, but just friends, and they're just probably both living at the property, and one poses as having some right to it, and the other one poses as having contract with that. And then the scam is you file a bankruptcy petition. There's an automatic stay. And then you get to stay a lot longer until, it buys you another year of screwing around in court. Unless the bankruptcy court is all over it and says, no, we're not participating in this nonsense. And for that to happen, let me tell you, it's got to be obvious. It's got to be obvious because all courts are going to lean on the side of due process and making sure, but that court is convinced that she is full of it. So is Judge Simpson at this point. So there we have it. That was fun. I like that. She sort of that. I think she's. I definitely think she's at least subset adjacent with the I don't consent BS. She does claim to have a contract, but that's probably with a co-scammer. It is possible too that these people did have some interest in the property and they're just normal people and they rented to her. That's a possibility. I don't think it's very likely, but that's a possibility. But if that is the case, they've been foreclosed on, blew off the procedure blew off the. We're post foreclosure now. It's not theirs. They blew off the eviction procedure, so they're out. This woman has nothing. The end. Robin Lee Miller sent that to me. That was a lot of fun. Like I said, I was a little delayed on it because I was actually doing law stuff for reals. It happens sometimes. It happens. Thank y'all for coming out. That was a lot of fun. I'll see you soon.